Good morning, ladies and gentlemen. Welcome back to another episode of PLA. I hope everybody's well rested. We've just come back from a long weekend over the weekend. Nick is also back with us from holiday, so welcome back to Nick with a new look as well. We've got two questions today on Property Law Alliance. The first question we'll be dealing with, Bruno will take care of it. This one is from Red Fritz, and it's from a YouTube question. So Red Fritz says that he is in a house. He says, I'm in the house that my mother passed away in, and I don't know if the hostile executor will sell it, right? I'm the only heir in her will, but the executor does as he pleases. I don't have any rights. There are enough other assets in the form of investments to cover costs and taxes. How do I protect myself against a blackmailer executor?
Sure. Look, so there is a relatively simple answer to this, and it comes down to utilizing the Master of the High Court in order to try and assist you. And so if it's as clean cut as the estate is liquid, and when I say liquid, it means that you have enough assets and money in the estate to pay off all its debts, leaving the property completely unencumbered. And by that, I mean, if let's say there's a bond registered over the property, there's enough money in the rest of the estate to be able to cover that bond. Because remember, guys, even if you have, if you own a property, but you owe the bank on that property, if you pass away, your family is not going to get it unless you've got an insurance policy that covers it, or you have enough money to be able to cover it. And that's why we often speak about things like trusts, where we put some of these assets in the trust for the purpose of avoiding a situation where when you pass away, all of a sudden you need to liquidate all your assets to cover all the debts. We rather like ring fence it into a trust so that it just carries on and the property stays owned by a trust, right? So basically, if in a situation like this, you're saying that you've got enough money to cover all the costs, all the investments, all the debt. So it's not just costs and taxes, but also all the debt. And this property could be transferred to you, but the executor is refusing, then it's a very, very different story, because that means the executor is not acting bona fide. Now, first thing that a person needs to look at is the contents of the will, right? Because I understand that you're the only heir, but what does it say specifically regarding the property? Does it leave the property as a legacy, or did your mom direct that the property be dealt with in a very particular way? Now, I'm assuming that because you're the only heir, that it's a kind of a, your mom said, leave the estate over to this beneficiary. So that's number one. If that's the case, you've got a very strong leg to stand on when you go to the Master of the High Court. You can present facts and financials to basically explain, look, I should be owner now, and this guy's simply just not transferring the property through to me, wants to sell it, and he's not explaining. So the Master of the High Court is an entire dispute process that you can follow, and they do respond. So we deal with this quite often. Yes, it might not be the fastest response, but remember, you're staying on the property, so you do technically have the upper hand where you're staying there. And you can lodge this objection with the Master of the High Court and run through the process, have the executor explain through his liquidation and distribution account. That's basically just the accounting record and budget of what the plan of action is. And with that, you'd be able to look at everything, all the assets, all the liabilities, and really understand why the asset needs to be sold. And if he cannot justify it, it's in the master's hands to remove him as executor, to make a call to, enforce. Otherwise, you'll obviously also have recourse to the courts, but I don't think that that'll be necessary just yet. So yeah, I do hope that answers that question. Nick, anything to add on that?
No, so I'm glad you mentioned it at the end, just the courts, because I think the most important thing, what Bruno said is absolutely correct. Your primary driver here is the master's office, and they have the deciding vote basically in respect of executive matters and estates. they're the ones that are going to make a decision. Generally, you wouldn't approach a court, and generally a court's not going to step on the toes of the master in administrating this estate. It's not their function. The one thing that has come up that I have done in previous occasions where there is a problem with the master's office or an executor who's doing something that creditors don't particularly like, is you can still approach a court for urgent interdictory relief. So you can say I'm taking the question here on face value, and you're saying that the executor's performing some dodgy transactions. If there is something and you're worried about the sale of your property, if the property is going to be sold imminently,
sure,
and you know that's coming, and you can prove that's coming, and you don't understand why, you haven't been received feedback, you are the sole heir of this particular will. It seems perfectly reasonable to me that you could approach court on an urgent basis to stop the sale pending a determination by the master in respect of the particular estate.
Sure.
You can have that ability to approach the court, but you still ultimately have to defer to the master to make sure that it's properly.
Absolutely. No, I totally agree.
100%. Well, thank you, Nick. Thank you, Bruno. That really, those two answers from those from both of you guys, it covers the question pretty well. I did have a backup question, but Nick, he covered that as well. So thank you, guys. So yeah, Red Fritz, I hope that answer came through satisfactory.